begin the session. Go ahead, Sophie. You are welcome to start.
Yes, hello everyone. Welcome to this webinar about the new workplace. My name is Sophie Maas. I'm an employment lawyer. I'm a partner at the Belgium Ius Laboris firm, and it is my pleasure to moderate today's webinar about the new workplace. I think we can all agree that the pandemic has been the biggest HR experiment ever, because all of a sudden we had to work globally from our homes. And then after 1.5 years now, I think it's also fair to say that the return to the office, or at least in some form, has become a reality as well. But it's also fair to say that remote working is here to stay. Surveys around the world are really confirming that both employees and organizations want to continue to work in one or the other form remotely, let's say a couple of days per week, going from 1 to, and even in some cases, 3 days per week. So what we see, and that is based on the questions that we receive from our clients globally, is that organizations are reviewing their workplaces, their strategies, and the way they work, and also how they want to do this in the future. And based on that, it's fair to say also that what we will see is that the new workplace, as it will look like going forward, will probably be a mix of different models, going from employees who work 100% at the company's premises, for example, in production sites, but also combined with employees who perhaps do a hybrid model where they work partially at the office a couple of days per week, and then perhaps 1 or 2 days per week from home, and perhaps also combined with some employees who work 100% from home. And besides that, we also see that employers in the new workplace, we see other concerns coming up, like concerns in terms of ethical investments, corporate social responsibility, climate change, etc., etc. So all sets of new challenges that employers will need to face, and where they will need to think about the strategies moving forward. And that is here where we Ius Laboris come in, because perhaps you do not know this, but we within Ius Laboris, we have different expert groups. And what we have done since the reopening of the companies and the firms globally is that within our expert groups, and we have 9 expert groups around different top expertises, we have looked at what were the questions that our clients are asking, and we have launched within our groups several surveys with asking our members from all around the world to respond to those surveys. And the result of this is a Q&A session, and it's composed of 40 Q&As in total around hot topics in relation to the new workplace going forward. And what we have done, and that has just been launched this afternoon on our website, so it's a real scoop here. We have a new series on the new workplace. You see there a screenshot. And what we have done, we have centralized, or we have grouped the different Q&As around 8 topics, which you see there. So the first topic is around vaccination, which is approached both from a privacy perspective and a discrimination perspective. We have a series of questions about health and safety, working time, reimbursement of expenses. We have also one about labor relations in the remote environment. Also questions around doing investigations remotely. Also questions about working from abroad. And then finally, also in relation to pension, about ethical investments. So what is now actually the purpose of today? Well, actually the purpose of today is that, and this is part 1, because we will have a second webinar as well, is to discuss with you the conclusions that we have based on those surveys with the different heads of the different expert groups. So I'm very happy now to introduce you to our panel of today. And who do we have on board? Well, first of all, we will have Emanuela from our Italian firm. She's the head of our compensation and benefits groups, and she will have a look at trends in relation to reimbursements of cost providing tools, etc. Then secondly, we will have Burkhard. Burkhard is a partner of our German firm, Klimt, and he had a look at, he is the head of our restructuring group, and he had a look at labor relations in the new workplace. Then we also have Janusz from our Polish firm. He is the head of our expert group in relation to internal investigation, and he did some surveys around doing investigations remotely. Then we also have Claire from our UK firm. She works in the pension group. She had a look at ethical investments for pension funds. And then finally myself, I'm the head of the immigration and global mobility group. And we within our group had a look at employees working from home. So this is what we are going to do today. And then in a second webinar, we will have the same discussions with the other expert group heads, namely in relation to vaccinations, working time, and also OHS. I think it's clear that there is still a lot to discover about the new working place, but we hope at least that we can give you some food for thought with our discussions of today and the results of our survey. So I'm now going to ask for Emanuela, if you as head of our compensation and benefits groups, if you can give us some insights on what you have discovered in your surveys and what you can conclude as global trends in relation to reimbursement of costs, compensation and benefits, etc.
Thank you, Sophie. And hello, everybody. It's a pleasure to be here. And I will immediately start to report the conclusion that we collect according to the 39 answers that we received from 39 countries who participated to our survey. First of all, and the first conclusion is that in all the countries, the reimbursement of the expenses or the treatment of the cost associated with working remotely is an issue. In 16 countries, the answer has been clear, and the answer has been yes. So in 16 countries, the employer has the obligation to reimburse or to pay directly the expenses suffered by the employees in connection with the work performed remotely, or to provide them with the necessary means to perform their activities. In 9 countries, the answer has been no. So specifically in Canada, Cyprus, Denmark, Finland, Ireland, Israel, Japan, New Zealand, and South Korea. However, in all these countries, there is always the possibility for the employer and the employees to agree upon a reimbursement of the expenses or to provide for an indemnity with some tax impact that I will discuss a little bit later. But more interesting is the fact that in 14 countries, the answer has been yes and no, or better, it depends, which is quite a common answer for lawyers. But in this specific situation, in these countries, the answer depends on the regime or the mode adopted for working remotely. For example, in Italy, there is a distinction between smart working, or we call lavoro agile or flexible work, and teleworking. And the main difference is that in teleworking, according to the teleworking new model of working, the employee is free to choose where he or she can perform or wants to perform the working activity. On the other end, in the teleworking model, the employees is obliged to perform the working activity from a specific place, which is different from the company premises, but it could be, normally it's the house of the employee. Only in this second model, the employer is obliged to reimburse or to pay for the cost of the teleworking. And I think that this main distinction is applicable in most of the 14 countries that reply yes or no to the question that we asked them. For example, the same thing, I think it's applicable in Belgium, where, I mean, reference is made to structural telework. Again, also in German, according to German law, it seems that if the employee is free to choose where he or she performs his work and is also entitled to have a workplace at the office, the additional cost for remote working or for mobile working are not to be reimbursed by the employer. The same principle we have in Colombia, where we have three different modes of working: working from home, teleworking, and remote working. And the same in Luxembourg. For example, in Luxembourg, according to the Telework Convention of October 2020, only the employer is obliged to reimburse and to bear the cost for the remote working only in case of regular teleworking and not in case of occasional telework. And there is also a threshold. So it is considered occasional telework if on average the employee work outside or at home or outside the company premises for less than 10% of the annual working time. We have another threshold, for example, in Mexico. And for teleworker, a teleworker is a person who works over the 40% of his regular shift from the place different from the company work side. The same distinction we found out in Poland and in Portugal. So as again, the main conclusion is that in those countries, if the employer is obliged to reimburse or to pay for the cost only in case of teleworking or in case of regular work performed outside the company premises. In the UK, there is a slightly different approach. Employers are not legally obliged to provide or to pay for equipment an employee requires to work from home. However, if the equipment is specifically needed to address a health and safety concern, or where a disabled employee requires, for example, an auxiliary aid, as a reasonable adjustment, employers will be liable to pay for the cost of the equipment itself. In the Netherlands, but also in Italy for teleworkers and in Sweden, there is an obligation to provide for an ergonomic place of work. And it means that the employer is obliged to pay or to provide the employees with the necessary means in line with the health and safety provision. So also health and safety provision has to take into consideration when an employee and the cost associate has to be taken into consideration when an employer decides to have the employee regularly work from home. But the second question and the second conclusion is, what are the costs that an employer has to bear? The answer again varies depending on the country, but we can make a general statement that if we consider teleworking or remote working performed on a regular basis, the employer has the duty to provide the employees with the necessary means and pay or reimburse the expenses incurred for their use. Of course, provided that employee can justify them. This is again a general principle that we can find out in most of the countries. In South Korea, there is an interesting principle. An employer is not required to reimburse any cost to the employees working remotely if the amount of the expenses is not excessive and it has been borne by the employee under normal personal life circumstances. Only if expenses exceed the employee burden under normal circumstances, at this point, the employer must reimburse the employee for the expenses. In Czech Republic, on the other hand, the labor code is crystal clear on this point, and the employee must be reimbursed all the costs that arise to him or her in connection with working remotely. Again, we have more or less the same principle in Brazil. In Bulgaria, well, there is a list of items that company has to pay or to reimburse. Again, also in Colombia and in Croatia. And going back to the Czech Republic, it's important to note that even if it's true that the employer must be, and that the employee must be reimbursed all the costs that arise to him or her in connection with working remotely, the employees must first request the reimbursement and then prove the amount of the cost to the employer in order to get compensation. In France, there is an interesting, we are more or less in line. We have to take into consideration what the National Interprofessional Agreement dated back 26 November 2020 provides. But in general, the principle is the same. So the expenses incurred by an employee needed for the performance of the duties and in the interest of the employer. And here there is no distinction where he or she works. With the approval of the employer, must be borne by the employer itself. And for examples of telework related cost, could be fixed and variable costs related to the provision of private premises for business, but of course, private premises for business, so specifically linked or used for performing the work activity. And again, in order to have a fiscal benefit, the employer can reimburse the teleworking expenses provided that the teleworker can prove the expenses by related receipts.
Emanuela, sorry to interrupt, but I think we will need to round up if we can finish.
Absolutely, sorry. Yeah. And only one point, there are only few countries in which it's possible to pay a compensation, so to pay an indemnity, and namely they are UK, Ireland, let's say Hungary, and also France, and also Canada. And in those countries, it's important to verify the ceiling, because in all of the countries there are, of course, limitation to the indemnities in order to have a tax benefit and having money not taxable for the employees. This is very important.
Okay, thank you very much. So Burkhard, move on to labor relations. So what are your conclusions based on going forward?
Yeah, thank you. I'd like to focus on two issues, but let me briefly say that basically all the consultation countries that we know will resolve the underlying consultation issues around new workplace basically along the lines of organizational changes. So apart from very few countries like Germany in particular, there is no specific law in place on consultation requirements regarding a new workspace. So there's nothing really to report in this respect. So that's why I want to focus on two other items. One is an interesting development in the digitalized world or new world of co-determination, cooperation, and labor relations. And that is the question on whether unions, in particular unions that have not been in touch with the company, like unions that have not agreed on tariff agreements with the company yet, whether these unions will have a digital access right in order to promote union activity within the company, but on digital platforms. That is a very new development, and we have run this with all our jurisdictions. Interestingly, only a very few jurisdictions have responded that this is already an issue or that they would grant unions access rights. For example, Russia and Poland. But that is maybe more a historical background of the role that unions used to play and still play in these jurisdictions. We have, and that was the trigger in Germany ever since the COVID litigation going on against German companies by the chemical workers union in order to have direct links on the company intranet, and in particular to be able to form communication groups and closed communication groups so that cannot be observed or controlled by the employer on the company intranet systems. Whoever is very much into IT, it will be Yammer groups that they want to have access to, where you can start having conversations without the company by their tools being able to supervise. And in order to promote this, the unions are demanding access to the email addresses of every employee, whether or not a union member. It is interesting to see that in the discussion in Germany, given the fact that there is a very high protection of unions under the constitution, we may end up in having a digital access right for unions. And we, as you know, we have a new government coming in Germany, and one of their big projects sponsored by the unions is to enhance this digital access right, which of course will then have an effect on cross-border. In the moment that this is available for the German unions, there may be other unions, in particular in the European Union, who will be targeting the same purpose. That's why we did the review. I think the outcome at the moment is that there is no legislation in place, specific legislation in place in any of the membership countries in the European Union and also beyond. But I think the general view, and we had a discussion in our practice group about this, was that once this becomes an item, maybe this in the end is a lesser question of labor law and becomes more a question of power and influence. And interestingly, the unions in Germany start to have individual tariff agreements or regulations with specific larger companies in order to modify their demands in a way that is acceptable under the data protection laws in particular, when it comes to the access to an employee data. And also, and that's something that I would recommend everybody who is involved with this to look at data security regulations put in place by the companies, which of course the unions will then have to observe. So that's a very frequent and recent trend that we see. There's another item, Sophie, I'd really like to bring to everybody's attention, which we see with the new wave of COVID coming in. We start to brief our regulators, our supervisory boards and our boards about imminent risks on our capabilities to uphold production in a moment where we will see an enormous risk of energy shortfalls, probably around January or February of next year. We will still have the supply chain challenges that we all face all over the world, plus the recent COVID changes, let alone like in my country and other countries where we have a strong increase in COVID cases. And with the discussion that we're currently having, like a very limited discussion about, how do we control the access of people who haven't gone under vaccination into the shop field, and can we exclude people who would refuse testing? For example, who would refuse the 3G plus or the 2G plus when entering the facilities. There is a very strong reaction from labor directors who have been speaking to over the last two and a half weeks, that recent surveys, in particular a survey by McKinsey, shows that about up to 25% of the labor force in factories have not undergone vaccination yet. And this is an analysis by McKinsey on a basis of developed industrialized countries. And so it is not possible for production companies to simply say, well, then you stay at home, because that will immediately kill the production process in a good part of our industries. And the combination of energy supply problems, supply chain problems, and potential COVID problems may come to a situation where the labor partners, the social partners, probably right at the beginning of next year, maybe even by the end of this year, will face business disruption risks that we need to bring to the attention beyond our labor relationship organization. And the companies who think a little bit ahead will already make plans for how to react in the production sites if we are probably unable to uphold some parts of our production sites in early next year. And it's not that we're coming about with a lot of recommendations here, as you can imagine, but we will throw this concern to you. One of my clients And they had a similar problem 2 years ago when the Rhine River was so deep in summer that no ships would be able to pass through Rotterdam into the Rhine and provide the Ruhr area in North Rhine-Westphalia in Germany with sufficient supplies. And therefore, there are plans in place on what to do with your production site if the Rhine River would not be able for shipping anymore. And I recommend to look at those plans, yeah, and share these kind of considerations with your colleagues, because that's exactly the kind of plans that we should start putting into place and start discussing with our social partners. So you can see this is less about, you know, imminent restructurings coming in, but maybe even worse about, you know, whether or not we will be able to uphold production process and production cycles in a similar way. Short-term work is not an option in this case because we need people to work for us. So we need to think ahead on how we probably would even let a good part of our workforce into our production sites, even though they refuse testing. I know that this is contrary to everything that is being currently discussed in the political environment, but I think the political environment is pathetically only looking at reactions to medical advice and is completely underestimating the workforce impact and the production impact that these discussions will have if we let them flow on and suddenly are all of the view that a 2G plus is an option for larger production facilities throughout the world and in particular here in Europe. And that is a thought that I wanted to bring into this discussion. Thank you, Sophie. Yeah.
Thank you. Thank you very much for that. Janus, you as heads of internal investigation, a completely other topic, you had a look at some impact on when companies have to do investigations. If you can, you're still on mute.
Yes. Okay. So let me start with very basic information. And one of the main conclusions is that it is all based and dependent on the technology and software if we talk about remote investigations. The following factors count. Level of proficiency in ability of employees to deal with different software and devices when they use them. So for example, in Germany, employers must ensure that their telework, remote work and privacy policies provide clear guidance to employees on the appropriate use of this media, stating what can be monitored or reviewed and the extent to which data on personal devices may be accessed by the employers or people who act on their behalf when conducting investigations. If this is complied with, employers may get access to the data that is stored by the employee. And of course, it should be linked to the precise allegations that are investigated and should be proportionate. Proportionality is probably one of the most important words in this context. Another very basic thing, safety and stability of the internet connection. I mean, this is one of the fundamentals when you're conducting internal investigation, and you should make sure that this is sure. Well, technical conditions which safeguard confidentiality. We saw and we see and replies that we received from our member firms show that much depend on the tools and measures in disposal of particular client. Standards required and expectations of particular client may significantly differ. For example, expectations of a financial institution investigating data leakage are different from the expectations as to the standards of internal investigation of a company producing furniture or investigating potential bribery allegations concerning supply of a raw material. This is my experience. That is really a good example of applying different standards when you conduct investigation, internal investigations. Another conclusion that is very important, I think, is that there are no rules or recommendations as to how to conduct remote investigation. There are some good practices. Maybe there is one exception. In Russia, the internal investigations conducted in a workplace is quite formalized, should be conducted in written, documents should be signed. And but it was just one of the exceptions that we saw. When we think about internal investigation conducted in a workplace, conducted remotely, I mean, it's important to remember that somehow we can call it employer's jurisdiction or employer's responsibility is limited. I mean, it cannot be applied to the home place where the employees is at the moment. It can be home, it can be hotel, it can be traveling. So we have no control as employers or lawyers representing employers on certain things, and we have to accept it. Most controversies discussed related to the witnesses' interviews and security of the communication, and at the end of the day, reliability of the depositions received given by the witnesses interviewed. One of the main reasons why clients or employers instruct law firms to lead internal investigation is professional privilege. Clients and employers expect that facts established in course of the investigation would be protected by the professional privilege and professional secrecy rules. In the so-called normal circumstances, such employee interviews are conducted in a place where professional security rules may be safeguarded. When you conduct an internal investigation remotely, your measures that you can use are limited. So problems that member firms mentioned or discussed, for example, different people having access to the process, like family members, like unknown participants who are present, or who may be present, or issues related to access to the video conference of people who are not invited. The question how they manage to get access to this communication. So this kind of problems. Let me give you an example of Canada, because they have quite clear recommendations as to the way how such remote interview should be conducted. So investigators should ensure that the interviewee is not recording the interview and that they are in a private area, no one is listening or coaching them. I mean, participation of a lawyer on the side of an employee is a separate issue. And I'm not going to discuss it now. In general, at the end, having in mind all the doubts that I've talked about, in general, feedback was quite positive. People were underlying the process efficiency, that remote investigations save costs, interviews go relatively smoothly. On the other hand, experienced investigators sometimes complain that this remote interviews are deprived of, to some extent, this aspect of non-verbal communication. Non-verbal communication is a very important factor that tells you a lot about witness credibility. And of course, for example, criminal practitioners may tell a lot about it. So from my perspective, that's all what I can say about internal investigations, Sophie.
Yeah, thank you very much. Perhaps I'm now going to say a word about what we have done in our group, which is immigration and global mobility. Actually, what we have examined is the question about having employees working abroad. Because as we all know, a lot of functions can be done remotely, and there is even research on that from the European Commission saying that 38% of the positions can be done remotely. So that means that it opens a huge opportunity for both companies and employees, because it actually means that we do no longer need to recruit in the country where companies are being based, and that the world is becoming one global talent pool which we can use. That is a conclusion from a practical perspective and from a digital perspective, but unfortunately, and that's very often the case, the legal world is not following so quickly. And there are some concerns or some considerations that as an organization that you need to take into account when you decide to recruit somebody who is just living and working in another country in a permanent way and will work from there. So that is actually what we have done. We had a look at some of the consequences thereof. And one of the first thing, because that's really always a question that we get from our clients, is the question, do we need to have a legal presence in a specific country where we want to employ? Because we have there found this brilliant candidate is working in a country where we are not established. Do we need to set up some company or a branch or whatever? Well, for most countries, and that's in particular the case for Europe and Switzerland, Mexico, Canada, it is not necessary to set up a company or a legal presence, but you might need some registrations for tax and social security purposes. But that is not the case for all countries. For example, in the more South American countries, but also in Russia, in Turkey, and the Emirates, there you will really need to have a legal presence and set up a company to be able to employ employees. But then there are also other countries where it may depend on the type of employees. For example, in Hong Kong and Peru, they require legal presence if you would employ foreign nationals. So that is kind of the first questions we looked at, just as a highlight, because that is something which I also see a lot in my practice. Then whether it is possible to employ or to use, because sometimes companies say, well, we don't want to have all the hassle around it. Can we not simply use an employer of record, which is something which is used in more Anglo-Saxon countries? But there, I just want to say we did not survey that, but just be very careful with that, because employers of records are not always legal in some countries. So you need to be very careful with that. The next question we looked at was more from an immigration perspective, whether companies or countries are developing new immigration policies and have digital nomad visas in place, which would allow just employees coming to a certain country to sit there and just work from there for an employer which is not established in that country. The conclusion there for most countries is no, we do not have something in place yet, but it's clear that that is an area where we will see probably things changing, because in Europe, in Estonia, which was the first to have it, we already have it in place, but now also Croatia and Greece has followed, so they have digital nomad visas in place. And apparently in Spain, they're also looking at it, and in Romania as well. So it's clearly a topic which is evolving at the moment. Also in more, I would say, exotic places, you have it also already, like in Dubai, Cayman Islands, and so forth. There it's already in existence. So, but that is clearly also a point or an area where we will see some developments going forward. The next question or thing we examined was to know, because in most cases you want to employ an employee abroad, you have your own templates, etc. Whether we can just use your own employment contracts, which are, for example, subject to the laws of where the company is located. Then the question is, can we do that? Or do we need to take into account some local laws which will nonetheless apply? Well, there for most countries, the response is, yes, you can do it, but watch out, or local laws will also apply. So you need to take that into consideration. There are some very few exceptions to that, like India, where it may depend on the number of employees you have. Also Russia, if the employer has no presence at all in Russia, it might be that local laws will not apply. So, but in general, local laws will apply, so you will need to take that into account. We asked the same question in relation to Social Security. Does it mean then that we will need to pay local Social Security? Well, there the answers are a bit more divided. It's easy in countries like Dubai and so forth, where there's simply no Social Security. So the response there is very simple, no. Or other countries like Hong Kong, where Social Security is not mandatory. But for most countries, the response is between yes, Social Security, local Social Security will apply, but also a certain number of countries responded, well, actually, it could, but it is not yet certain because it depends on a number of factors. So that is also something you will need to look at, whether local Social Security will apply, because the response is not that straightforward for all countries. And then, of course, the last question or the last topic we examined was taxes. There, unfortunately, will local taxes apply? Yes, local taxes will apply. Unfortunately, we will need to pay them. Only exception is, of course, Emirates, where there is simply no taxes, but aside from that, local taxes will apply. And then the last question, which was also responded in a very unanimous way, was, do we have a risk of a permanent establishment if for a company if we would have an employee working from us in another country where we do not have any legal presence? But there it was responded by everyone in the same way. Potentially there might be a risk, and you will need to examine that. And then we asked also some, what are the criteria, or how can we assess this? And also there we saw some consistency. In most of the cases, it will really depend on what is the employee doing there. Is it the core activity of the company, or is it just auxiliary activities? Can he negotiate contracts? Other thing, how permanent is the situation? Is the remote working obliged? Do I have, as an employer, I have access to his home, etc., etc. But definitely a point of attention is the permanent establishment risk if you have an employee working from abroad. So that was, in a nutshell, a bit the things that we have examined. In more detail, you will find it on the website. And then I'm now going to Claire. Claire, you will also discuss something completely different from a completely other aspect. It's not about remote working, but another challenge that in the new workplace moving forward that we will see. It's about corporate social responsibility, about ethical investment obligations. So thank you.
Thanks, Sophie. I think the link to the pandemic and what's happened since is really that localized lockdowns resulting in the last 20 odd months, I think it's given us all a taste of what a cleaner environment might be like. So streets devoid of transport, and certainly in the UK, it certainly hit the headlines, these thermal images coming from space showing just how much less energy was being consumed across the globe. When it comes to the approach by pension funds to environmental, social and governance related factors, or ESG for short, the heat, I think, is very much on in parts of the globe, but in others not so much. Before starting with the kind of the UK, because that's an easy platform to build from in terms of what other countries are doing. Before the pandemic in 2017, the Task Force on Climate Related Financial Disclosures basically published 11 recommendations for all organizations to help them identify, assess, manage and disclose climate-related financial risks and opportunities. And the UK government really latched onto that and outlined plans for all large companies and large asset holders, all listed companies and all large asset holders to disclose in line with those recommendations by 2022. And we're now seeing those changes start to come through. So broadly speaking, it's being phased in, but we're starting with the larger occupational pension funds first. So those with 5 billion or more assets, with funds with 1 billion or more assets following suit from next October. And schemes will basically have to produce and publish on a publicly available website, accessible free of charge, a report on how they've met the relevant climate change governance requirements and inform members of the publication of that document And recognizing how technical this area is and the fact that trustees of large pension schemes are going to have to grapple with things such as emissions-based metrics, they need to up their essentially their knowledge and understanding when it comes to climate change. That's not the end of the story for the government there in the UK, because under further proposals with effect from next October, schemes with 1 billion or more assets and certain authorised schemes will be required to calculate and report on the extent to which their investments are aligned with the Paris Agreement. So the goal here being to limit global warming to well below 2 degrees above pre-industrial levels, or actually trying to also actively pursue efforts to limit it to 1.5 degrees above those pre-industrial levels. And this is not the end of the line either, because in the UK also the government's issued a call for evidence earlier this year looking at the S in ESG, so the social aspects that go into investing. So, and looking at the financially material risks or opportunities involved in that, such as practices within a company and its supply chain, such as workforce conditions and diversity and inclusion, which is obviously dear to everyone's heart here, and the products indeed that companies are selling. So looking further abroad, following our survey, what is happening in relation to ESG and pensions around the globe seems to vary quite widely. It's a mixed bag. In some countries, there are no ESG requirements in relation to pension funds, not even a requirement to disclose to members what the fund is doing about it. Examples here are Chile, Finland, Luxembourg, and Mexico. And the primary driver, I think, therefore, in some seems to be to operate the pension scheme as profitably as possible for the benefit of its members, which, of course, is the primary driver of most pension schemes. But the governments in a lot of countries are trying to put a layer on top of that to try and make people think about ESG. For other countries, for example, Slovakia, as pension funds must disclose information on ESG investing, it anticipates, I think, there that it could drive pension funds to invest more ethically, so perhaps forcing grassroots changes. For EU member states, just as it is in the UK, a lot of the change is being driven by what's called the Second Pensions Directive, known as IORP2, which requires schemes to implement good governance and disclosure when it comes to ESG. So countries there, we're talking about, for example, Bulgaria, Cyprus, Germany, Italy, and the Netherlands. But governance such as a requirement to consider ESG and disclose measures that doesn't necessarily translate into pension funds being actually obliged to invest more ethically. And I think that's the sort of, a lot of countries are stopping short on that. So an exception there is perhaps the Netherlands, where it's prohibited from investing in companies that produce, sell, or distribute cluster munitions, for example, or crucial components of those. So that's a very quick snapshot of our survey. And as the recent United Nations Climate Change Conference, which took place in Glasgow, showed, also known as COP26 in the UK, the work here, I think, has only just begun, and it's a highly technical and quickly developing area. And we may yet see, I think, in the future requirements to invest more ethically, not just to consider it and not just to tell your members what you're doing about it.
Okay, so thank you very much for that, Claire. I'm just looking at the clock. I had one very overall question left, and which was just, perhaps some of you can respond to that, and then we will pass to questions, was we are all employment lawyers and looking at it from a very, I would say, global perspective. What do we think are the most biggest challenges, or what are the area you think as employment lawyers we will see in the near future the most developments, or is anybody have a thought about that, and especially where global organizations should be aware of? I see Burkhard, you're on mute. So
no, I'm unmuted. Yeah, can I?
Yeah.
No, really, I think there is a big area which we will all be seeing out of this post-COVID scenario that we're all hoping for. And that is a constant shift of HR activities from manual into digital and from digital into artificial intelligence supported digital. And I think we will all have to learn, and I know from discussions even with lawyers who represent unions and works council in this, that we all realize that the patterns under which we have discussed these items in the past, in the last 10, 15 years, are completely outdated. All attempts to describe these tools that will now be available in detail in documents and discuss it in a consultation process are a failure. And everyone is very obsessed with it, but at the same time, super frustrated, even on the side of union representatives and Works Council representatives, because we all feel that in the consultation process, we are not able anymore to go to the heart of it, which is what is AI really doing when we use it in an HR process. And on the left-wing side of the spectrum, we see here in Germany, for example, a very famous law professor just putting the hypothesis in a law journal article to say that the mere use of artificial intelligence for HR tools is a discrimination in itself, because the way it's being configured will speed up any built-in potential discrimination issues and will it make almost indefensible for a company to use it. And there's such a variety of issues in the field of HR tools being supported by AI that I think then that this is to my point of view, the real hot next topic. But we are so focused and obsessed these days about, how to make access and how to have everybody being vaccinated and whatever it is, yeah, and how to deal with those who do not want to vaccinate and so on. But, we have to understand the world behind this COVID pandemic is rapidly changing, and that we need to go back into a scenario where we just say, okay, let COVID be COVID, but we have to look at the real issues of the next 10 to 15 years in our industry and in our HR world.
Anybody else thought about it? Yes.
If I may, maybe it's more narrow view, but I think that especially in close to the end of the pandemic, we hope that it will end soon. I think that one of the challenges, especially for employer and of course for HR consultant, will be how to structure an efficient bonus scheme, bonus plan in order to reward and motivate employees. Because I think that considering the change in the working model, I think that the traditional concept of what we call in Italy subordinate employment contract is going to change, because I think that employers should think about a way of measurement the result of the employee more linked to the result than the time spent by the employee at the working place. So I think this is an issue for increasing also to gain and to share the positive result of this change between employer and employees, and to increase the efficiency of the organization.
Thank you. I'm still looking at the time. I also saw that we had some questions. I'm just gonna, I think one is, I guess, for you, Burkhard, in relation to giving email addresses to unions. Do you think that's an issue from a data privacy perspective, as from whether they can do that? You're on mute.
I'm sure
Yes.
it is an issue, very clearly, and there's disputed view about this. For example, the highest German labor court has held that this, under certain circumstances, can be admissible. It's a question of interpretation of Article 6 of the regulation, where it is in fact a legitimate reason to have an information being provided to labor representatives. And maybe you will have to define what is a labor representative, and maybe you have a different view to those who you have entered into collective agreement with, and those who would simply approach you for the first time, like a minority union. And so this is nothing that you can decide with a yes or no, but you can certainly not rule out, and I think there's case law even here in my jurisdiction, rule out completely that people take the view that the laws on data protection are banning any kind of union access into the system and in providing email addresses. So it's not a black and white answer. Sorry for that, but probably it's not a black and white field either. Yeah.
Yeah, thank you very much for that. I'm just quickly looking at some other questions. I see here also a question. What about different tax implications when employee is working from different countries? I think. Well, there I think the answer will be you will need to look at the double tax treaties, and most likely if an employee, but it all depends on the circumstances and the double tax treaty. It can indeed be that we end up in a salary split situation, but as with taxes, it's always a bilateral approach. So you will need to look at it, and it might indeed be that you will need to pay in both countries. But it's very difficult to say a generic answer because it's very based on the circumstances. Another question I see here, but that I think I do not know whether anybody of us can predict this, but the question is, in many EU countries, companies are forbidden to ask for digital COVID certificates. Do you foresee a change in this so only vaccinated team members can access the company premises? Anyone, any thoughts about that? Burkhard?
I know that people are starting to ask to scan these systems. I'm a little bit nervous about this because the information is going through a third-party provider, if it's an app or even the scanning process. So unless you can make sure that this highly individual and protected data is not made available by pure coincidence and circumstances to an unreliable third party by just using a scanner system or an app that is now being provided, I think there is a way to resolve this. Whether, as I was just mentioning earlier, whether it's so smart to completely exclude non-vaccinated people from the premises, just think about the underlying data, and maybe it's something that sounds good in the first place and becomes a big problem on the second view.
Thank you. And then I have one last question. I think, Emanuela, it's for you. Moving forward also on differences and how we will evolve, do you think does a principle of equal treatment between remote workers and normal employees apply? What is normal, but anyway. So
exactly, it's the new normal maybe. Yeah. So in general terms, yes. And as far as compensation is concerned, maybe we have to think about if there are indemnities of payment linked to the fact that the employees suffer any disadvantage for working outside home. So, for example, I'm thinking about a ticket restaurant that we have in Italy. We already have some court cases that clearly stated that the remote workers are not entitled to receive payments for them or receive them when they are working at home, because the reason of the granting doesn't exist anymore because they are not working outside, and so they do not have to receive this meal voucher for taking lunch outside their home. And so I think that, of course, the answer is yes, but it depends on the indemnity and of the payment that are linked to the way in which the working activity is performed.
Thank you very much. And I think we are just in time at the end of the webinar. I know we went a bit in all directions, but it was a bit to give you a flavor of the 40 Q&As that we have. And we would really invite you to go to our website and have a look, because there you will find in more detail all the questions and all the answers, which on an average have been responded by 40 jurisdictions. So I'm now gonna thank you very much also again for your attention. Also, thank you very much for our panel. And I'm gonna hand over again to the central team, who I think will just do some closing remarks. So thank you very much.
Bye.